Good afternoon, everyone. Welcome to the Senate Finance Committee. Good afternoon, Senator Kramer. We are now voting. It's Thursday, March 13th, and this is voting list number 13. What a coincidence. Thank you all for being here, and we're going to start with Nathan, Senate Bill 423.
Thank you. Senate Bill 423, you'll recall that last year the legislature passed the Physicians Assistant Modernization Act after several years of work. And so similarly, this bill is the result of a lot of discussion, planning, and negotiating. And I can say that the Board of Physicians worked very closely on this bill with representatives of physicians and the hospitals. And with the addition of one tweak that was made this morning, I'm told that all parties are comfortable with this bill. And so with that said, in very broad terms, I'll describe that Senate Bill 423 alters, clarifies, and makes consistent provisions of law regarding physicians, physician assistants, and allied health professionals regulated by the Board of Physicians. And so among other actions, the bill alters disciplinary grounds and the disciplinary process, licensure requirements, board duties, specified notification requirements, and provisions governing the Allied Health Professional Advisory Committees. The bill also alters existing civil penalties and establishes new administrative penalties for specified violations. And the bill also repeals obsolete and redundant language and makes clarifying and conforming changes. So the amendments, I'll say that the reprint that's before you is about 102 pages long, including some 47 pages of amendments. And again, broadly, the amendments make additional technical clarifying and conforming changes. Some of these changes include defining the term employer and then applying that term throughout the bill, eliminating potentially duplicative reporting requirements. The amendments further correct a typo in the physician compact, requires the board to be notified of a name or address change within 30 rather than 10 days. Under current law, I believe that's 60 days. Lowers from $25,000 to $15,000 the amount of civil penalty the board may impose for certain violations, alters the grounds for discipline by the board for patterns of excessively or medically unnecessary treatment and willfully hindering investigations, requires reporting of disciplinary actions by employers, specifies circumstances for which a report must be submitted, specifies certain reports that if certain reports are not subject to PIA requests, authorizes the board to extend the reporting period for good cause. That's a change that was made this morning at the request of the Hospital Association, and authorizes rather than requires advisory committees to advise the board.
Do you have any questions? If we have no questions, can I ask, I'm going to first thank Nathan. How many, 106-page bill?
102, I think.
102-page bill. So thank you for all your work on that. On Senate Bill 423, do I have a motion? Senator Guile, do I have a second? Senator Reedy seconded. All in favor of Senate Bill 423? Unanimous vote. Thank you. Nathan, next is Senate Bill 456.
Correct. So Senate Bill 456 is a bill where the Finance Committee is second, Triple E is primary, and voted the bill favorable with the amendments that you see in the reprint unanimously last night. So Senate Bill 456, as amended, expands eligibility for the Maryland Dent Care Loan Assistance Repayment Program to include dentists and dental hygienists who are employed on a part-time basis. The bill also requires the Higher Education Commission's Office of Student Financial Assistance in collaboration with the Department of Health to establish prorated loan repayment assistance for part-time dentists and dental hygienists participating in the program. The amendments remove from the bill a requirement for the Insurance Administration to report on the use of online credentialing systems by dental insurance carriers. The chair asked me to further explain that there is an amendment that has been shared around related to the part-time dentist provision of the bill, and asked that I share that the amendment was considered and rejected in the House as well as in Triple E.
Do I have any questions on Senate Bill 456? Seeing no questions, can I have a motion for Senate Bill 456? Thank you, Senator Reedy. Do I have a second? Senator Guile? All in favor of Senate Bill 456? Not unanimous? All right, we need to call the roll. Senator, I just want to mention, a lot of the part-time hygienists and dentists are working moms, and they choose to work part-time because they have children. And so by excluding part-time, we are going to exclude the women that are trying to be professionals. Call the roll, please.
Senate Bill 456 favorable with amendment. Vice Chair Hayes? Yes. Senator Kramer?
Yes.
Yes. Senator Reedy?
Yes.
Yes. Senator Mount? No. Senator Jackson? Yes. Senator Washington?
Yes.
Yes. Senator Guile?
Yes.
Yes. Senator Hershey?
Yes.
Yes. Madam Chair?
Yes.
Yes. 9-1.
I need to check something and we go to the floor, it may become a yes. Just need to,
It's your option, Senator.
thank you.
Okay. Senate Bill, should we wait for Senator Ellis to get back?
Yes.
Yes, let's wait for Senator Ellis. Next bill is Senate Bill 749, Nathan.
So Senate Bill 749, for which there are no amendments and therefore no reprint, requires the State Board of Dental Examiners to issue a license to a dentist or hygienist licensed in another state within 15 days after receiving the applicant's completed application if the applicant meets the requirements for licensure. And so the bill also specifies that that the requirements a dental radiation technologist authorized to practice in another state must meet to qualify for a certificate in this state. So it specifies what they must meet in another state to practice in Maryland. If an applicant meets the requirements for certification, the board must issue the certificate within 15 days after receiving the completed application. The cross-file bill passed the House unanimously this week.
Any questions on Senate 749? Can I have a motion for Senate Bill 749?
Move favorable, Madam.
Thank you, Senator Kramer. Do I have a second?
Second.
Senator Hayes, all in favor of Senate Bill 749? Unanimous vote, thank you.
Next bill on the list is Senate Bill 919, which, as amended and reflected in the reprint before you, alters the definition of practice audiology by specifying that it includes the conducting of screenings related to the auditory or vestibular conditions in the human ear, or as required by federal or state law. So the bill also specifies that the ordering and performing of certain scanning or imaging of the external auditory ear canal may occur as it relates to the auditory or vestibular conditions in the human ear. There are some amendments that are offered by Senator Lamb that are reflected in the reprint. Those amendments, which are on page 2, strike a provision referencing the use of any means known to the science of audiology, specify that to evaluate, diagnose, manage, and treat auditory or vestibular conditions in the human ear must be related to hearing loss or hearing disorder. Specifies that the ordering of cultures, blood work, and radiographic imaging must be done in consultation with a licensed physician, and alters provisions related to the conducting of health screenings as I described. There is no fiscal impact.
Madam Chair, an appointment in the morning with the governor's office to discuss some of these amendments, and I would kindly request your consideration to hold it one more time.
Second.
Absolutely.
Thank you, Madam Chair.
Okay, Senate Bill 1005.
Yes, Senate Bill 1005, for which there are no amendments, expands the authorized uses for grants from the federally qualified health centers grant program to include the acquisition of land for the construction or use of a federally qualified health center. Again, there are no amendments, there is no fiscal impact, there is no opposition.
Any questions on Senate Bill 1005? No questions, I have a motion for that bill.
That's it for me.
Senator Mounts, do I have a second? Second, Senator Reedy. All in favor of Senate Bill 1005? Senator Jackson, you with us? Senator Washington? Okay, thank you. Unanimous vote.
We'll switch to Dave then.
Oh, now we're going to go to David.
Okay. 495.
Okay.
Okay, if you go to the top of the list of the voting, you'll see, once again, that Senate Bill 431 is on here. This is the administration bill that makes changes to the law governing registration of apprenticeships for the purposes of promoting apprenticeships across the state. You have a reprint in front of you. I'm not going to go through the bill again, but I'll just go to a reason why it was held, and that was because Senator Washington had an additional amendment suggestion. So regarding the timing of when or ratios may be adjusted from 1 to 1. If you go to page 4 of the reprint, the senator worked on this language with the governor's office. And you'll see at the very top, instead of just recommend a deviation from the minimum ratio, it specifies a more definitive time frame at the time of or subsequent to registration, meaning that every new apprenticeship program that they want to come in or seek recognition for has to be acknowledged by the commission or the Maryland Apprenticeship Training Council. And so at that time, they can recommend a deviation from the ratio. But there also may be instances where an existing program may want to change their ratio. They can, so it allows for that time frame too under this language. And to answer a question about who has regulatory authority here, it's actually the Division of Workforce Development is required to pass regulations to implement all these provisions.
Can I have a motion for the amendment that we just discussed?
Or do you want to take them all up together because you haven't done that yet?
Okay, so a motion for the amended bill? David?
Yes, a
Can I have
motion
a
for the
motion for the
amended bill.
amended bill 431?
I move the amendment.
Thank you, Senator. Do I have a second for 431? Senator Hayes?
Yes.
Okay. Senator Washington, Senator Hayes for Senate Bill 431, the governor's registered apprenticeship bill. Okay.
Take the roll.
Will you please call the roll, Tammy?
I know we've talked about this bill a lot. Is this adding $5 million, or this is money in the budget? It's already in the budget. It's in May. Where are we at on the fiscal side?
As amended, the bill struck the $5 million mandated appropriation from 27 to 30 and just said the governor may put in funds in the budget. The current budget has, I believe, according to fiscal note, the initial fiscal year impact is 1.6, and I believe that money is in the budget to start creating incentives for advancing apprenticeships in the state. That's good.
Okay, all right. I'm still not quite sure that we need this bill, so anyway, but no, I appreciate it, thank you.
Yes.
All right. Ready?
Conversation going on here. Senate Bill 431, Senator Washington motion, Senator Hayes seconded. All in favor of Senate Bill 431?
Yes.
All right, we need to call the roll, Tammy, please.
Don't like apprenticeship?
Senate Bill 431, favorable with amendment. Vice Chair Hayes?
Yes.
Yes. Senator Kramer? Yes. Senator Reedy? No. Senator Mounts? No. Senator Jackson?
Yes.
Yes. Senator Washington?
Yes.
Yes. Senator Guile? Yes. Senator Lamb? Yes. Senator Hershey?
No.
No. Madam Chair?
Yes.
Yes. 7-3.
Six to 3.
Oh, because Senator Lamb is back. Yes, Senator Lamb. David, are we doing another one of your bills?
Well, I have one of the bills that has Amber's name close to it. I've volunteered to help out with. So if you want to, you can go straight to Senate Bill 750. Senate Bill 750. It's on the second page of the voting list. This is the bill that involves adding faculty to collective bargaining rights for state employees. And there's a reprint in front of you, so instead of describing what the bill as introduced would have done, I'll just go straight to the reprint. And if you see by the title on page 2, it's no longer about faculty. There's amendments offered that alter the bill to apply only to part-time faculty in the University System of Maryland, St. Mary's College, and Morgan State. Often these part-time faculty are referred to as adjunct faculty. So I may use the terms interchangeable. So there are some technical changes to page 1 of the
David, I need
reprint.
to stop you. I'm looking for my bill so I can follow with you, and I don't seem to have it.
It might be in the stack.
I don't see it.
You have it, right? You're not even looking.
That's campus.
That's okay.
Does everybody else have it? Would you mind, and then we'll get him another copy? Oh, here's a copy. Okay. I don't have it for some reason. Okay.
Okay.
David, thank you.
All right. Well, made me worry there if I didn't give it to Mickey to pass out. So anyway, at the top of the page, you'll see that the title's been changed to part-time faculty instead of just faculty. The amendments continue, and most of the changes relate to changing faculty to part-time faculty. On page 2 at the top, you go from part-time faculty to faculty regarding employee organizations as recognized by the State Labor Relations Board. On page 3, these are the substantial changes to the bill. So it came in as faculty means, and now you're defining part-time faculty as non-tenure track, temporary, contingent, or contractual adjunct employees of a system institution, Morgan State or St. Mary's College, whose primary assignments involve academic classroom instructional responsibilities and who teach more than one class per semester. So this is the definition that will apply to those part-time faculty at the 3 or at the 2 institutions and then the system who will be eligible for collective bargaining. There's also an additional definition here that says part-time faculty does not include officers, and a rather long description of the faculty at the University of Maryland Global Campus, because they are largely all part-time faculty and they have special circumstances on how they teach, so they're not going to be included as the traditional adjunct faculty that the bill will cover, and of course student workers. Going through to page 5 of the reprint, there's amendments here to the section that says who collective bargaining does not apply to in terms of state employees. And these adjustments are made because of the change to part-time faculty. So on lines 7 through 8, you see brackets are struck, which says now again that faculty at the university system are not covered by collective bargaining. Lines 10 and 11, a lot of part-time faculty are contingent, contractual, temporary, or emergency employees. So normally they would not be included as under collective bargaining, but this would say except for part-time faculty. And then there's lines struck on 14, contingent, contractual, and except for faculty, and at the next one, except for faculty. This is struck because this would take folks who teach at the professional graduate schools, such as lawyers and doctors. They would not be covered if they're part-time faculty teaching. They would be covered by collective bargaining. At the bottom, on lines 23 and 24, there's 2 brackets that are struck, and this restores authorization for a governing board to determine who is a supervisory, managerial, or confidential employee. And at the bottom, there's a technical change made due to the fact that the bill just refers to part-time faculty. On the final page of the reprint, instead of 2 bargaining units established for faculty and contingent contractual faculty, you'll just have an additional bargaining unit at the universities for all eligible part-time faculty. And and there's another amendment that says that these bargaining units, this new bargaining unit may not elect to engage in collective or may not engage to consolidate with other bargaining units at other system institutions for the purposes of a combined memorandum of understanding. And the effective date of the bill is pushed from July 1 to 2025 to 2026.
David, I'm looking for the global, I missed where you pointed out the global school.
No, the language that excludes the faculty at the global campus is on page 3 of the reprint. After line 9, adjunct faculty who teach a standardized, pre-designed, and temporary curriculum per course. This applies strictly to the faculty of the University of Maryland Global Campus.
Thank you.
They would not be covered by this.
No wonder I couldn't find it. I was looking for the word global. Okay. Any questions for David on this bill from Senator Kramer, Senate Bill 750? Any questions?
Senator Kramer has his light flashing.
Senator Kramer has his light on. Thank you, Senator.
Madam Chair. Madam Chair, I would simply state that I appreciate the fact that we are taking a tiny and incremental step in doing what absolutely is the right thing. I think we're going to see how the university system reacts. Number one, I've heard already stories that based on this bill as amended, at least one campus may be looking at not hiring adjuncts so that they don't have to follow the provisions of what, should this pass, be a new law. So I think that the university system needs to understand that if they are dealing in bad faith as we pass this small incremental legislation, that I hope this body will have a greater appreciation for the university's lack of respect for the women and men who are the faculty on our campuses, and maybe with a little bit of time, we as a legislative body will see that the university system does not collapse under the weight of simply providing the opportunity to bargain collectively, and that going forward, we might be able to pursue moving in the right and appropriate direction to provide collective bargaining for all faculty at the university system. So thank you, Madam Chair.
Thank you for the comments, Senator. Do you have any other questions on Senate Bill 750? Seeing no questions, can I have a motion?
I would move favorable as amended, Madam.
Thank you, Senator. And do I have a second?
Senator Jackson.
All in favor? I think we better call the roll.
Yes.
Senate Bill 750, favorable with amendment. Vice Chair Hayes.
Yes.
Yes. Senator Kramer.
Yes.
Yes. Senator Reedy.
I'm gonna have to be a no.
No.
Because my friend here has worked so hard on these issues.
Senator Reedy, no. Senator Mounts, no. Senator Jackson, yes. Senator Washington, yes. Senator Guile, yes. Senator Lamb,
Yes, but I echo Senator Kramer's concerns. It's a tiny step forward, appreciate the effort here. That's important to some of these faculty, but we still need to go.
Senator Hershey,
Yes.
We won't stop until we have to.
Change my vote to no, please.
Senator Hershey, no. Madam Chair,
Yes.
yes. 7-3, the bill passes.
Senator Kramer's on, won't stop till $200,000 professor a year.
Wait till Senator Ellis gets back for Senate Bill 365. He's the one that held it. And then we're going to go to, are we doing 664? Okay, thank you.
Okay. Senate Bill 664, as amended, requires the comptroller to consult with certain stakeholders to study and make recommendations regarding the enforcement process for miscellaneous state business licenses issued under Title 17 of the Business Regulations article. Amendment 1 is technical, and Amendment 2 strikes the bill as introduced. You have a reprint in front of you. Basically, this bill as amended is struck due to some due process concerns related to assigning criminal liability as contemplated by the bill as introduced. Instead, we're creating just a study that the comptroller will undertake. The study language is all on the back page 4. The comptroller must consult with, at minimum, 6 stakeholders, but more if they are identified, and then must report on a number of things, including a review of the process that is currently used to enforce state business licenses, whether civil citations could be used rather than or in conjunction with criminal citations to enforce the business licenses, recommendations on how to ensure the Field Enforcement Bureau can properly identify and contact the owner, operator, or other responsible party, and just generally how they can more streamline enforcing this miscellaneous state business licenses that we heard so much about with the citing of the store clerk who has no business and no control over the business.
Senator Mounts? You like the study? Senator Mounts moved favorable. Who seconded it? Senator Reedy? All in favor of Senate Bill 664? Unanimous vote.
Now, the comptroller's not gonna stand up on the floor and admonish the committee.
She can't.
The comptroller says it doesn't, they can do it in-house with no.
This was there were so many questions. We met multiple times with the comptroller's office. There were just so many questions. We have, I think, Senate Bill 678, Senator Rosa Pap's bill, electronic health networks. I thought there was going to be a motion to hold that. Senator Reedy, I thought so.
I think we've had some more questions, and I think we should hold this and see if we can get some more answers.
Thank you, Senator Reedy. Next, we have Senate Bill 767, Senator Jackson's bill for the Calvert County Sheriffs.
Yes, Senate Bill 767, it generally establishes the right for full-time deputy sheriffs and correctional deputies in the Calvert County Sheriff's Office to collectively bargain and establishes a process for them to do so. You do have a reprint, which generally strikes the bill and process as introduced and establishes a collective bargaining process as negotiated by the affected stakeholders. Amendment at page 2 subjects any additional funding required by an agreement to be approved by the county commissioners. And then additional amendments at page 3 simply alter the collective bargaining process as offered by the sponsor, supported now by the Senate delegation and supported by the county commissioners. We have letters from all 3. This is a local bill.
My vice chair has a question.
Yes. Amber, at the hearing, this is the bill where the county commissioners kind of control the budget for whatever reason they wanted to exclude themselves from the conversation, which didn't make sense, and the sheriff testified to that. How was that compensated for?
Sure. So they were all, the Calvert County Board of County Commissioners and the bill sponsor negotiated the language that you see in the bill. Basically, what the county commissioner was saying, they didn't want to exclude the ability of these officers to collectively bargain. They thought they were the wrong party to be bargained with.
Right.
But because they control the budget, this language about the county commissioners approving the collective bargaining agreement between the sheriffs and who they're going to bargain with is how they kind of compensated for that. So they would bargain with their employer for their wages and working conditions, and then anything that may increase budget or needed funding would go to the county commissioner for approval.
Yeah, makes sense. Thank you. Thank you so very much, Madam Chair.
Thank you. So do I have a motion for,
So move.
okay,
Favorable as amended.
Senator Hayes, do I have a second?
Read it.
Okay, thank you. All in favor of Senate Bill 767? Do I need to call the roll? No,
No.
unanimous, thank you. You're gonna learn to like it. Next, we have Senate Bill 928.
Senate Bill 928 prohibits, except as authorized under federal law, a person that is not accredited by the U.S. Department of Veterans Affairs from receiving compensation for preparing, presenting, or prosecuting a veteran's benefit matter, or advising, consulting, or assisting an individual with regard to a veteran's benefit matter. Likewise, the bill prohibits a person that is not VA accredited from receiving compensation for referring an individual to another purpose for the preparation, presentation, or prosecution of a veteran's benefit matter, or advice, consultation, or assistance with such a matter, or guaranteeing, either directly or by implication, that an individual is certain to receive specific veterans' benefits or a specific level, percentage, or amount of veterans' benefits. The bill also repeals certain advertising and disclosure requirements related to veterans' benefit services. Any civil or administrative penalties collected by the Office of the Attorney General in an action under the bill must be deposited in the Maryland Veterans Trust Fund, and a violation of the bill is considered an unfair, abusive, or deceptive trade practice under the Maryland Consumer Protection Act and subject to both civil and criminal penalty provisions. There are no amendments, there's no fiscal impact to the bill. And that's all I have.
Thank you. Senator?
Thank you, Madam Chair. I think we might be discussing a possible amendment. Can I hold this, please?
You can. Senator Kramer asked to hold it to the end of the calendar. Do you want to?
I will yield to Senator.
Okay, so you want to hold it till the next voting
Yes,
session?
please.
Work on the amendment. Thank you.
Next, we have Senate Bill 972, which increases from 3 to 5 the number of members of the Anne Arundel County Board of License Commissioners that the governor must appoint, alters the appointment process and eligibility requirements for board members, and alters the license application process. You have a reprint in front of you. There are amendments offered by the sponsor beginning at page 2, at line 12. This is where they're altering requirements for selecting board members. So generally, the Anne Arundel County House and Senate delegation recommends, creates a list of recommended individuals, and each board member will be selected from that list. Allows a former chief, the amendment at line 19 allows a former chief inspector to appoint it to the board after 1 year rather than after 5 years. At page 3, there is language struck that is then replaced by a prohibition on the use of race and ethnicity information for making license determinations. And then further down after line 10, the amendments establish graduated penalties for violations of the alcoholic beverage laws rather than the set penalty of a fine up to $2,500 as was under this current law. There was no opposition at the committee hearing, and there is a letter of support from the Anne Arundel County delegation.
Senator Lamb.
Yeah, thank you, Madam Chair. I know I talked to council and I have been talking before about this, just to correct a drafting error here. In the reprint line 14 of page 2, I think to keep in the spirit of this provision, it should be no more than 3 members of the board may belong to the same political party. So if we can just do a verbal on that.
Yeah, that's just a technical.
Yeah.
Yes.
Any other comments or questions on Senate Bill 972? Can I have a motion? You motion, Senator Lamb. Do I have a second?
Second.
Okay, thank you, Senator Reedy.
It's good local.
All in favor of Senate Bill 972? Unanimous vote, no one opposed. Okay, Senator Hayes' bill's next, 1008.
Senate Bill 1008, as amended, modifies the Maryland Small Business Development Financing Authority's long-term guarantee program by specifying that a guarantee provided under the program may be supported in additional forms than under current law, including by an irrevocable letter of credit, an official treasurer's check, funds on deposit in an escrow or other depository account, and any other legal instrument promising a financial institution restitution or reimbursement for its loan losses within the limits of the guarantee under current law. The terms and conditions of the legal instruments described may not be so onerous as to discourage the financial institution from ultimately offering the loan. Amendment 1, you do have a reprint. Amendment 1 is technical, and then there are 2 amendments offered by the bill sponsor at page 2, which generally just strikes the full faith and credit of the state language and instead authorizes the authority to guarantee loans in these additional forms as described.
Senator Hayes, do I have a second? Senator Jackson, please let me call the vote on Senate Bill 1008. Everybody in favor? I have a motion and a second. Unanimous vote, thank you.
Next on your list is Senate Bill 1021, which prohibits a registered cemeterian permit holder or the owner of a cemetery that is exempt from registration and permitting requirement from selling or transferring a cemetery in whole or in part to another person without the approval of the Director of the Office of Cemetery Oversight. The bill also establishes requirements that must be met before the Director of Cemetery Oversight approves a sale or transfer of a cemetery and authorizes the state, a county, or municipality to acquire an abandoned cemetery for specified purposes. You have a reprint. There is one amendment offered by the bill sponsor. It's on the very last page of the bill at the back. It just authorizes a party who disputes the decision of the director regarding a sale to bring an action in accordance with Maryland rules.
Any questions on Senate Bill 1021? Senator Reedy, you have a question?
I do, and the sponsor and I have been talking offline, so this
Okay.
isn't a surprise, but there was a concern raised about one part of the bill dealing with a person who owns and operates a bona fide religious or nonprofit cemetery in this state, that should be exempted from this because it's a religious organization. And I was given an amendment to basically try to exempt religious organizations. And I want to give the sponsor a chance to answer or give some input or whatever. I wanted to see if we could do that or why we wouldn't want to do that, and maybe just talk about it for a minute. So I don't know if
So the sponsor would like to respond?
if he'd like to.
Yes. Thank you, Madam Chair. Yeah, I have spoken with Senator Reedy and the advocates, and I'm not so concerned about the sale of the cemeteries with regards to religious institutions and nonprofits. I'm more concerned with the ability of loved ones, family members who have loved ones buried there, to have a say in where they want to, move their loved ones in case of a sale. So, I told the advocates that I'm willing to work with them to try to tailor that and exempt them from the other parts of the bill. So that's where I'm at.
So, Senator Jackson, am I hearing you say you're working on an amendment?
Yeah, I will be working with.
So you think you can have it ready by tomorrow so we can vote it?
Sure.
Because if we don't vote tomorrow, it's not going to get out before crossover, which isn't the end of the world, but we'd like to get things out before crossover.
And I know that was the desire to be sure it gets out, and I don't want to hold that
So
up.
we'll hold it while you work on the amendment.
Okay.
Thank you.
Yeah.
Sure.
I'm curious, Senator Reedy, why would you want religious institutions exempted from?
Well, I think that I'm representing some people who've expressed this to me, including the Catholic Conference, who are concerned that it's a slippery slope when once you start controlling what religious institutions, this kind of thing, that it just becomes a slippery slope into getting more involved. I understand Senator Jackson's point, and I support families having the right to know. So I'm just wondering if it was just this just came to my attention and our attention here recently in the last hour or two. So there was somebody that offered. I think they did submit a potential amendment at the hearing, but I just don't know that the communication got where it needed to be. So I told him we'd work on it. Is all, and I don't even mind. Well, if we have time, if we can vote it tomorrow and still be okay, then it's good to hold it, and we'll see if we can come up with something. And if we can't, we'll just have the vote and move forward.
Senator, you have all afternoon to work on it as
Thank
soon as we finish
you.
voting.
Just what I was planning on working
I
on.
know.
Right. Got it.
Okay, so we'll hold that. Senate Bill 1023, Senator Jackson, employment discrimination, fire and rescue public safety employees' use of medical cannabis.
Senate Bill 1023 prohibits an employer of a fire and rescue public safety employee from disciplining, discharging, or otherwise discriminating against the employee with respect to the employee's compensation, terms, conditions, or privileges of employment, or limiting, segregating, or classifying its employees in any way that would adversely affect the employee's status based on that employee's use of medical cannabis. You have a reprint in front of you. There is one amendment recommended by council and offered by the bill sponsor that appears at pages 9 and 10 of the bill. On page 9 at line 31, we're just striking medical, so it's clear that the employer can prohibit any cannabis use, medical use or recreational use as it relates to impairment. So an employer can still prohibit an employee from being impaired by cannabis while performing the employee's duties. And then at page 10, we have a parallel change that authorizes still authorizes an employer to prohibit the use of cannabis, but strikes language that would have limited to within 12 hours before reporting to say while on duty. So the 12 hours, there was concerns about whether that could be enforced. But what can be enforced is not using cannabis while on duty and not being impaired by cannabis while at work. There's no fiscal
Have a question.
impact and there was no
Okay,
opposition at the
Senator
committee hearing.
Washington, did you have a question?
Yes, I do. Thank you. I do have a question about, did you say it strike the 12 hours or?
So
kept the 12 hours in there.
what happens here is the cannabis, the initial bill came in saying that an employer could prohibit an employee from using cannabis within the 12 hours before reporting for a work assignment. The issue with that is how do you determine that a person has used cannabis within 12 hours? The testimony we heard at the hearing indicated that impairment can be tested. So we're still authorizing an employer to prohibit a person from being impaired at work, and we're authorizing an employer to prohibit the use of cannabis while on duty, but the 12 hours before just is an untenable provision as far as enforcement goes.
Okay, there was a lot of good stuff you said there. Just simply, does it have the 12-hour provision still in there?
Correct.
It does, okay. That does sound concerning to me, because we're only doing this for firefighters, right?
Yes.
And we don't do it for alcohol or any other substances that are legal.
So there are policies, and employers can adopt policies about prohibiting the use of alcohol or about prohibiting using alcohol while you're at while being impaired at work from alcohol. So I think it puts this on par with how we do treat alcohol by passing the bill. Right now, an employer can outright prohibit the use of cannabis even if the person has a medical certification. This is authorizing a person to use their medical cannabis, and if they test positive on a urinalysis, they have the medical certification, there cannot be an adverse decision from the employer.
Got it. Okay.
Yes, Senator Guile.
Well, I wasn't finished.
Oh, I'm sorry.
And it applies to firefighters, obviously, that are hired. Does this apply to any firefighter, volunteers, professional firefighters? Does it apply to everyone? Yeah, I know, but still, it says firefighters.
It would be employed by a municipal corporation, a county, the state airport authority, or a fire control district. So that is what it is defined as in the bill.
Got it, okay. I do have some questions about the bill, so I would like other folks to have some comments on it too, but I have a lot more questions on the bill too.
All right, we'll come back to you if you have more questions. Senator Gao?
Yeah, thank you, Madam Chair. I guess the one thing I was thinking about, well, first of all, just to clarify, and I think this is the case, they have to have this has to be for medical use, right? So this is
Correct.
Sort of like the medical card or whatever. This has to be for medical use.
Right. So this is prohibiting an employer from taking an adverse employment decision based on the medical use of cannabis. They must have a medical certification for this to apply. The prohibition language strikes medical because we didn't want it to be confusing that the employer could prohibit medical cannabis but not regular cannabis. So I think we just took out that so it's clear that any type of cannabis can be prohibited as it pertains to impairment at work and use at work. So those things an employer may still prohibit.
Okay, so just so I can understand what you
Sorry.
just said. That's okay. So this is specifically, you can't discriminate against somebody if they're using cannabis on the basis for medical use, but they can't be impaired regardless of what the use was for, whether it's for medical use
Right.
or whether they can't exhibit signs of impairment, right? They can
Correct.
still prohibit that. And then, thank you, Amber. And then one other question, I can't remember, but I feel like, were there some counties that already had some sort of like non-discriminatory policies, or they could actually like do this? We're just saying, right, or something?
I do believe we heard testimony to that, but I don't know which counties that that applies to.
That's okay. I feel like there was something, but that's all right. All right, well, thank you. Thank you, Madam Chair.
Okay, Senator Lamb?
I know that Howard County has had an ongoing discussion about how to enact this kind of a policy, but they haven't actually enacted it yet. I'm not sure if other jurisdictions have had this policy enacted. Obviously, this would require there to be a policy. I do think it's important to highlight that this is one of the few professions where they're having difficulty getting recognition to be able to use medical cannabis. That we, as a body, have already recognized that medical cannabis has benefits and has use and value to certain individuals. But because of some of the limitations in place and restrictions here, it makes it very difficult for firefighters, if not impossible, to be able to use medical cannabis. And so without this kind of policy, it would be really difficult for them to have their local jurisdictions recognize this as a possible use. And it would, in fact, probably push more firefighters to use opioids, which obviously we're concerned about as well. And so, I think in that way, this is to help move the ball along so that firefighters can have the same ability as we do to be able to use medical cannabis if we feel like there's a need for severe pain or any other condition that it works for. The other difference here with alcohol is alcohol, you have a blood alcohol level that you can either blow into or someone can do a blood alcohol test. And that gives the snapshot of time of what your blood alcohol level is. Cannabis is a bit different in that it can stay in your system for a while. So they've had to have different tests, and that's why there's actually an oral test that is now being considered that would capture cannabis use in the last 15 hours or so. So to address Senator Washington's question about the 12-hour thing, if you use within the last 15 hours, potentially that oral test would pick up on it. So just a little bit of background there, but that's why, this bill is important to these folks.
Thank you, Senator. Can I go to Senator Reedy and then I'll come back to you? Senator Reedy?
Yeah, actually, I support this. I support the bill, and I was at the hearing and hearing some about how do we be sure we distinguish between actual, making sure somebody's not, using recreational and high or whatever, but I actually, Senator Lamb makes a good point about some of the things that are happening with technology. And also, I do think it's really important. First responders, were hit very hard by the opioid epidemic. And so, I've always felt it was a bit hypocritical the way we've looked at medical marijuana. If we do believe that it's a medicine, as a General Assembly, then, it ought to be able to not be discriminated against. So, I mean, I'm good with it. Again, I was glad we checked to be sure that you could obviously discriminate against if you have to not be impaired, which makes sense. So, I support the bill. I'll move favorable, but I understand we have some more discussion.
Let's wait and see what Senator Washington has to say.
Thank you, Madam Chair. I bring this up because of my work on police reform and accountability, and we were able to, try to change some of the language on marijuana usage of people who wanted to apply to become police officers, or folks that are police officers that have to use medical marijuana, but then they can get fired for that. To say that we can only do this for one specific profession and not the others that could use this type of protection becomes a concern for me, that it does open up a can. How does this, my question would be, how does this lead, how do we make sure that this leads to protections for a lot of employers that are public employers, public employees here in the state? I don't think this is a bad bill, but there's some concerns that I have with it.
Senator, I hear you, and I understand your concern. No one else has brought us the bill. This bill was brought by Senator Jackson with, support from the firefighters, and we've heard from them multiple years. And they do seem to have more injuries because of the work that they do. I'd be happy to consider bills, the committee would be happy to consider bills from other occupations, but I don't want to do anything that hurts this bill because it's been a few years and I think it's time. So you're welcome to bring a bill that addresses other occupations.
Yeah, thank you, Madam Chair. I've heard that before in many committees that I've sat in that bring this bill next year, and then we'll consider it. And the bill doesn't go a lot of places.
That's not this committee.
Okay.
Thank you. Senator Hayes?
Yeah.
We'll come back.
No, I have reservations about the bill only because, I thought that, and Senator Lamb brought up some good points, but I thought when we passed the adult use, we made allowance for employers to set their own guidelines, and we said that whatever the employers establishes their HR guidelines, they can be enforceable. And so I'm still not clear why we really need this exception if we gave, employers the discretion to implement their own. And I wonder if council could speak a little bit to that. Did I hear that incorrectly? That we pretty much left it up to employers to set their own policies around HR?
And that is true as it pertains to adult use cannabis. As it relates to medical cannabis, the door has been left open. There's nothing in statute that says one way or the other than if it would affect a federal contract. Employers can always make hiring decisions based on cannabis use if it affects a federal contract, there's a federal job, anything like that that would require them to not use cannabis. And sorry, I lost my train of thought there. This just is reflective of a policy position that the committee can make or not on whether we want to treat medical cannabis the same or differently than adult use cannabis. And I think in a lot of ways, the General Assembly has passed laws showing that we do treat medical cannabis differently. Further, the bill retains provisions that would authorize employer from adopting policies and procedures to prohibit certain things as relates to on-the-job activities. So no impairment, no use, any of those things on the job. So it does retain the ability of an employer to make those decisions. But it's treating this more as a prescription medication. For instance, if you did a urinalysis and you tested positive for opioids, but you have a prescription for an opioid, that's going to protect you, whereas cannabis has not been treated that way, even though we're using it as a medicine. Where if you test positive for cannabis and you have a certification for use of medical cannabis, it doesn't matter, you're not protected.
Right, but I think to Senator Hershey's point that he brought up in the hearing, there's no real way to tell the difference between medical or cannabis other than like the potency of the TNC. There's no real way to test for it. I guess the validator here is, I guess, having a card. Like as long as they have the medical card.
The medical card plus a doctor certification. So you can have a medical card. The medical cards don't expire anymore, but you have to have a valid certification, and that certification must be renewed every year.
Yeah, I guess
by a doctor.
Yeah, I guess hindsight 2020, like different employers have different, things that affect their employees. And I guess when we did adult use, we probably should have just said the same thing as it relates to medical, giving them the authority to establish their own. I just feel a little bit uncomfortable about going this way about doing it.
So, and this doesn't affect private employers. These are all
Right,
public
municipal
employees. But
Yeah, I got it. Thank you, Madam Chair.
Do we have any opposition from municipal employees when we had the bill?
there was no opposition at the bill hearing.
Good. Let's see, Senator Lamb?
Thank you, Madam Chair. Just to kind of address some of the issues that have come up. I think Amber actually touched on a lot of them in your explanation there, which I think is just important to highlight, which is that this is really just kind of level setting cannabis on the medical use side, right? So, I think the state has a stronger interest in protecting patients' rights and the ability to use medical cannabis. These individuals, firefighters, shouldn't be set at a disadvantage to be able to use medical cannabis compared to other populations. And so this is the intent to help protect that ability for these employees to be able to use that. And these are folks, as you've heard in your testimony, are very prone to injury, right, and prone to pain, prone to illnesses that can lead to debilitating diseases. And if we as a body have recognized that this is important for other populations, for the general use of the public, here we have an ability to extend that protection to firefighters as well. To answer Senator Washington's question on police, I think, my understanding we've had this issue kind of working its way through in Howard County, so I know a little bit more about this. But I think originally the firefighters wanted to include all public safety, but were told that there's like a federal provision issue. And so that was why they didn't extend that to include police and other law enforcement, which was focused on firefighters because it wouldn't run afoul of some of the federal issues that were out there. So, I think just some things to keep in mind. I think there is also a way to be able to test for this with an oral swab. Not only are they gauging whether someone is impaired, right, which is ultimately, the real test of whether or not someone can be on the job or not, because they can still be using cannabis legally, recreationally, but they just can't be impaired on the job. And so this oral test would be able to help verify and confirm whether or not they've used it within a certain window of when they came on duty, and also help address some of the impairment issues.
Okay, good discussion. I don't see any other questions. Oh, Senator Mounts.
Just one last question. In what other instances has this been established in the code?
When you say this, you mean cannabis use?
Yes, this specific.
I think this would be the first bill to establish a specific employment standards for the use of medical cannabis. There are policies and procedures at certain state employees that choose not to perform urinalysis and tests because of because the General Assembly has passed, legislation making cannabis use legal, and not taking those things into account. But there's nothing in statute that says they can't do that.
That's what I wanted to clarify. Thank you.
Okay. Seeing no other questions, do I have a motion for Senate Bill 1023? Senator Lamb, who seconded it? Senator Ellis. Welcome back, Senator Ellis. I'm happy you made it out. We held a couple bills for you.
Thank you.
You're welcome. Okay, all in favor? I think we need to call the roll.
Senate Bill 1023, favorable with amendment. Vice Chair Hayes? No. Senator Kramer?
Yes.
Yes. Senator Reedy?
Yes.
Yes. Senator Ellis?
Yes.
Yes. Senator Mounts?
Yes.
Yes. Senator Jackson?
Yes.
Yes. Senator Washington?
No, and in explaining my bill, Marylanders right now in a state where we have approved medical marijuana as well as recreational marijuana can be discriminated against at their job. They can be fired at their job for the use of cannabis, and we have legalized it. This piecemeal approach is not helping the vast majority of Marylanders that need this protection. There was a bill, Madam Chair, last year that I proposed to help with that. And I believe we need to move bills like that. That's going to help that's going to help all Marylanders that decide to use medical marijuana or recreational marijuana. And so that's why I'll be voting no on this bill.
Thank you, Senator. Senator Gall.
Senator Guile, yes. Senator Lamb?
Yes.
Yes. Madam Chair?
Yes.
Yes. 8-2, the bill passes.
Okay.
The next bill you have on the list is Senate Bill 1026. It's an emergency bill establishing that Title 11 of the Financial Institutions Article, which governs licensing requirements for various types of consumer lenders, generally does not apply to a person that acquires or is assigned, in whole or in part, a mortgage if the person does not otherwise make mortgages, a mortgage loan if the person does not otherwise make mortgages or engage in the mortgage lending business, or an installment loan if the person relies on another person to service or collect on the loan and does not otherwise make installment loans. This requirement does not apply to specified provisions of law governing the sale of a loan account to an unlicensed person. The bill also establishes the Maryland Licensing Work Group to study and make recommendations on licensing requirements for persons that provide financial services in the state. The work group must report its recommendations by December 31, 2025. You have a reprint in front of you. There is one amendment on the last page of this reprint. And this amendment is establishing that it's the intent of Section 1 to be clarifying for current law. That was added because up until a court case, the estate of Brown v. Ward, passive trusts that held pooled mortgage loans were never required to be licensed. The Office of Financial Regulation has never interpreted our code as it exists today to require those licensures, but the interpretation in the estate of Brown v. Ward case expanded the scope of the statute beyond the previously understood scope, which would now, if without this bill, would require these passive trusts to become licensed. There's also received testimony from the Office of Financial Regulations that 6 mortgage lenders and a number of other financial institutions that buy mortgages in the secondary market have stopped doing business in the state of Maryland already until this is addressed. There is, there's likely no fiscal impact.
There is an amendment, though.
And there is the amendment, which I just explained, is at the back, sorry, is at the back of the page, which is explaining that the intent of this act is to be clarifying existing exemptions for these passive trust entities that don't do any servicing of the loans, they don't collect on the loans, they just sit in the passive trust. If there's servicing needed, a licensed entity or person would service that loan.
Do I have a second? Senator Mounts? Any discussion? Can we call the roll?
Senate Bill 1026, favorable with amendment. Vice Chair Hayes?
Yes.
Yes. Senator Kramer?
Yes.
Yes. Senator Reedy?
Yes.
Yes. Senator Ellis?
Yes.
Yes. Senator Mounts?
Yes.
Yes. Senator Jackson?
Yes.
Yes. Senator Washington? Yes. Senator Guile?
Yes.
Yes. Senator Lamb?
Yes.
Yes. Madam Chair?
Yes.
Yes. 10-0.
Okay, we're going to do Senate Bill 1036, and then we're going to go back to the bills that we held for Senator Ellis. So 1036.
Senate Bill 1036 authorizes the holder of a Class D license or an employee of the license holder to deliver alcoholic beverages within Howard County in the same manner as the holder of a Class A license. There are no amendments, there is no fiscal impact, there was no opposition at the committee hearing, and there is a letter of support from the Howard County delegation.
Who moved favorable? Senator Washington, can I have a second? Senator Lamb? All in favor of Senate Bill 1036, local bill? Unanimous vote. Okay.
Yeah, that's right, thank you.
Yes, we need to take care of that excellent sponsor, don't we? Okay. Senator Ellis, we're going back to Senate Bill 495, which was your bill. We held it for you to return from EEE.
Senate Bill 495, as shown in the reprint, alters the authorized uses of the opioid restitution fund to include operating expenses and personnel costs for the opioid enforcement unit within the Office of the Attorney General. So the amendment adds an annual report and terminates the bill's provisions after 4 years.
Do I have any questions? Do I have a motion? Senator Ellis moved favorable. Do I have a second?
Second.
Senator Kramer seconded. I don't see any questions. Let's call the roll, Madam.
Senator Reedy. Oh, okay. With the amendment.
Senate Bill 495, favorable with amendment. Vice Chair Hayes?
No.
No. Senator,
Where are we?
495.
Senate Bill 495.
You're a yes, you're a yes. Yeah, I'm a yes.
Senator Kramer, yes. Senator Reedy?
No.
No. Senator Ellis?
Yes.
Yes. Senator Mounts?
No.
No. Senator Jackson? Yes. Senator Washington?
No.
No. Senator Guile?
Yes, but can I just explain my vote real quick? So, I had some reservations about this bill, and I put some thought to it, and my hope is that some of this directed funding for the opioid enforcement unit of the Attorney General's Consumer Protection Division will help with some of the resources that I know the Attorney General has asked for. And in particular, my hope is that it will free up some resources from the other work that they are doing in the Consumer Protection Division, especially to enforce some of the important consumer protection measures that we've passed here in this committee and out of the Senate and the General Assembly at whole. So thank you. Thank you, Madam Chair.
Thank you, Senator Powell. Senator Lamb?
How does Senator Washington vote?
He voted no. He voted no.
You voted no. All right. I'll vote yes, but explain my vote.
I have a lot of reservations, but so appreciate the time that have been put into this and don't want to hold back the Office of the Attorney General from doing their work. But I do want to emphasize to them to kind of take note of what was in the opposition testimony.
Thank you, Senator.
Madam Chair?
Yes.
Yes. 6-4, the bill passes.
Oh, thanks.
Thank you, Senator Lamb.
I'm just checking.
I think the Veterans Benefits Bill, is that the one you held? No.
Senate Bill 365, the Nonprofit Organizations Navigator.
Yes. Okay.
So you do have a new reprint that incorporates an amendment proposed by Senator Ellis. and Ashland just distributed an alternative proposed amendment that we just received from the bill sponsor. They are not substantially different, and I have not had time to review if there is an effect from one or the other. But if we look at page 2 of the reprint, you'll see the language that is proposed by Senator Ellis. It would prohibit the navigator from providing services to certain nonprofit organizations that provide a total annual compensation exceeding $250,000 to a single salaried employee. Senator Kagan's language, proposed alternative language, moves it to more of intent language, saying it's the intent of the General Assembly that the navigator provides services to smaller and mid-sized nonprofit organizations for the purposes of this section, meaning those do not pay an employee more than $250,000 in annual compensation. So they both have the annual compensation. One sets it as the General Assembly's intent, the other makes it a prohibition that the navigator may not do this. And if Senator Ellis would like to speak to his amendment. Senator Ellis.
Yeah, so, we pass a law, and basically, that's what we mean. So why do we have to say it's the intent of General Assembly? I mean, we show our intention in the language, so I believe it's too many words, and does the same thing, really.
We never have too many words.
No, I'm trying to limit my words, Madam Chair. So that's it.
Okay.
I mean, for what it's worth, there's like oftentimes litigation where they're trying to determine what the legislative intent, was for a particular piece of legislation or statute. And so I think by making abundantly clear what's the intent is, I think that's part of the reason why, I suspect. I mean, that being said, I think I did hear from the bill sponsor that there were some concerns, I think, and that were probably expressed to Amber, that there was concerns by Commerce about how it's not very realistic to expect the navigator to request compensation amounts for employees or other information before providing services to the nonprofit, and they're just worried about extra research or litmus tests before a nonprofit can be helped. So, I mean, I do think that, what is this, one person, the navigator, one single person?
Correct.
And to have to do some sort of, I think I do agree with you, what Senator Ellis, the point that Senator Ellis was making, that, and I think there's some information about how there's some big nonprofits out there. That being said, I would probably guess that a very large, very profitable nonprofit probably doesn't need the help of a navigator. I don't think they're going to reach out to this particular one person. I have to guess that if this is a large nonprofit that's well-funded, that they have a host of attorneys and grant writers and other people, and they have zero need for a navigator. But I mean, that being said, I understand the intent, and it's part of this discussion. So thank you. Thank you, Madam Chair.
Thank you. And we talked today, Amber and I talked today, one thing about nonprofits is you can always pull up their 990 and see how their profits are and how much they're, so I think this is an easy thing to figure out for the navigator to help, the smaller organizations. So thank you for that. Do you have something else? No, you said what I was going to say. Thank you. Senator Reedy?
I do want to add on, not to be necessarily contradictory, I agree with Senator Guile that a lot of the bigger nonprofits may obviously have more staffing, may be more aware of things, but I will tell you, they also have more people be like, ooh, there's a navigator. Your job is to call that navigator once a month and find out. And I'm not even blaming the large nonprofit for doing that. I mean, so in a way, I kind of like really limiting it. I don't really know that I want the bill. I don't understand why we have massive state government agencies with lots of employees. I don't know why we need to designate a position. I don't know why Commerce couldn't designate this and say, hey, and I'm not picking on Commerce. There's lots of state agencies where people are working a full day, but they're not busy for 8.5 hours a day, 9 hours a day, and they can't have time to work on this. You can have a team of people that do it. So, but I think the amendment makes the bill a lot better. So let me just say that.
Thank you, Senator. Senator Matz?
I was just going to follow up on that. I support the intent of the bill and what the bill wants to do, but with regards to the bill in general, I mean, it's taking a very messy situation and it's not resolving it. It's just going to make it more messy for a lot of the nonprofits in my district. So I've got big concerns with the legislation. But as far as the amendment.
Why is it messy?
Well, because the concept, the endeavor of going after grants for different nonprofits, you know, there's a lot of, like I say, hearsay. There's a lot of uncertainty. There are some beacons of light, but to add one more to the mix that isn't going to be able to solve everyone's problems just makes things more difficult for a lot of the smaller nonprofits. I like the amendment. I think the amendment is helpful just to sort of carve out the two. But just in general, following up, talking about the bill, there's definitely a need. I mean, there's also a need on the other side on grant follow-through and the whole completion of the grant. There's so much time and dedication that's given to just after through that reimbursement process. I don't want to go on, you know, my own personal issues that I've dealt with, you know, for nonprofits in our district or the ones I even work with. And I think of whether they're going to access and benefit from a single navigator on the Eastern Shore. I don't think hopes get real high about that. I just wouldn't predict that.
Well, I think we put an amendment on that they have to report back, don't they?
We did. So at the back, which we have discussed a couple times, that I didn't address it specifically here, only Senator Ellis's amendment, but at page 9 of the bill, some amendments offered by the chair adds a reporting requirement regarding the effectiveness of the navigator position, and also sunsets the bill after June 30th, 2027, so that if this navigator has not been effective in the role based on the report and the data that we get, the bill would terminate. If the General Assembly decides that the navigator's great based on the report, the legislation could be extended.
Okay, can I have a motion? Did I have a motion on this one? No.
May I just clarify, Madam Chair?
Yes.
The motion would be on the bill as amended with Senator Ellis's amendment.
Right.
Correct?
Right, motion as amended. Senator Ellis, will make a motion? Thank you. Do I have a second? Senator Kramer. Come on, guys, wake up. Wake up. Okay, we have a motion and a second. Let's call the roll.
No one likes.
Senate Bill 365, favorable with amendment. Vice Chair Hayes? Yes. Yes. Senator Kramer? Yes. Senator Reedy?
No, and just explaining my vote. I think the intent of it's good, and I'm glad we have the amendment. A lot of us have been talking about the overall budget situation, the need to freeze hiring as a possible solution. It seems wrong to me to then, for me personally, to turn around and vote for adding a position. So I'm going to vote no.
Okay. Senator Ellis?
Senator Ellis?
Let me explain my vote before I say, it's always good when we can have government helping people, especially our nonprofits, our smaller nonprofits, who are doing great work for our citizens, spend money that the government doesn't have to spend. So with that, I want to vote an enthusiastic yes.
Okay.
Senator Mounts?
Just quickly vote no, and then just to explain my vote very quickly, I support the intent of what this is trying to do. They wanted a quick solution. You could go look right to the government and look at the follow-through on the execution of grants that have already been awarded and clean that up first, and then try to get ahead of what's going on.
Okay. Senator Jackson?
Senator Jackson, yes. Senator Washington? No. Senator Guile? Yes. Senator Lamb? Yes. Madam Chair?
Yes.
Yes. 7-3, the bill passes.
Did we hit everything? Cover everything?
That's all I had.
Okay. Yes. So-
On Senate Bill 431, I would like to be recorded in red, please.
I'm sorry, which bill?
431.
431, in the red, okay.
Thank you.
Can you change the vote, madam? Okay, we took care of it. Before everybody leaves, we're going to have a little discussion.